Welcome to Legal Listening, where audio Obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today on the podcast, we are getting into some new content over here, and we're going to read for you JW and Canada. So this is going to be a part of a little bit of a series we're going to try to do about some class actions content. We're going to try to get some of that up. I personally love class actions. I did a lot of class actions work in law school, and they tend to be very, 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 very long decisions. So they're a little hard to put up, but we're really going to try to break into it in the new year. So this case specifically is very interesting because it sort of deals with what happens after the class action is over. So it involves an individual who was a class member under the Indian Residential School Settlement Agreement, the IRSSA. And if you were a claimant under that agreement, you had to go through this sort of independent adjudicative process that was set up in the settlement. So it's the independent assessment process, or like IAP is what it's usually called. So this is saying, okay, I'm a claimant and the action is settled and I am going through this adjudicative process that's in the settlement and I get a result that's not fair or not good or not what I wanted. Like, what happens then, right? Like, it's literally like, well, what do we do after the class action is over? What happens to the class members then? Mm-hmm. So had you ever heard of this one, Zach?
I hadn't. Like I said, the class action thing has always been kind of like outside of like what I knew in law school. But like, I think I do regret not doing it. I wish I could have taken more classes in law school, insofar as like I love to learn and I love school. Like, I don't love doing the work necessarily, like writing papers for marks, but like I love learning it. That's the fun part for me. But this sounds like to me like a great case, because I think you have an interesting intersection here between class action law and then you have administrative law coming in as well, like the role of administrative and adjudicative bodies and the role that the court plays in overseeing them and what happens after the class is completed. It's just, there's so many moving parts to class actions that it blows my mind that you're like, I know this. I was like, how can anyone human know this?
Yeah, no, it's super interesting. I'll throw it in the show notes. I wrote a blog post about this case for the class action clinic last year because the court's really, really split. You know, the majority comes along and says, you know, this person didn't get what they settled for. So we are fine with intervening as a court in a settlement because this is not what they agreed to in the settlement. And then you have a concurring opinion that says, no, courts can't do that. They can't just intervene if that's not what the parties get. That's not how this works. But they do think they should intervene here because the head of the IAP indicated that in this specific case, the wrong outcome was given by an adjudicator, but that he, as the head of the IAP, had no mechanism to fix it. So because there was a gap in the settlement, the concurring opinion says, yep, that's okay. There's a gap. We can intervene. Whereas the dissent, because there's 3 decisions in this case from the court, says no, there is no gap. We cannot intervene. A contract is a contract. A settlement is a settlement. You get what you settled for. We cannot do this. There's no reason for the court to intervene here. This isn't an administrative law. We can't do this. So it's very interesting how, you know, you have 3 groups of judges who have 3 very different opinions on how you should even be reading these. Like, you know, the dissent is saying sort of, this is a pure contract. We have no business here. Whereas the majority is saying, no, like you have to consider the context that this is a residential school, that you have to consider what the theme, like what the parties intended when they signed the settlement. It's very messy, but so interesting if you can sort of like wrap your mind around the framework of where the case is actually taking place.
Yeah, I think, like I said, to me, that's what's always been interesting about class action litigation in particular. And this isn't something I'd ever really thought about, like what happens after the class action has been settled and resolved. Like, what if something goes awry in the administration of the I hate to use the word, but the award or the end result? Like, yeah. What happens from there, right? If it goes awry and then you get administrative law and it always comes back to admin law.
Yeah, well, and so, like, obviously, like, shameless Windsor plug, but that's the reason the class action clinic exists, right? Because, like, what do you do? Like, what happens to the class members during and after this process is over, right? Like, obviously, they have class counsel, but that might not always be accessible to them, and there's other, you know, people far smarter than me have commented on all of these things, and it can get really messy. It's a very technical but also human type of law that can be very interesting. So yeah, we hope you guys enjoy this one. I am going to throw a big content warning on this, not so much for the meat of the decision, but the introduction and the facts. It does involve someone who was sexually assaulted while attending a residential school. So with that in mind, please take care when you're listening. As always, if it's not for you, don't worry about it, but we do hope that you enjoy this one. J.W. and Canada Attorney General. Heard October 10th, 2018 and April 12th, 2019. On appeal from the Court of Appeal of Manitoba. The reasons of Chief Justice Wagner and Justices Abella and Karakatsanis were delivered by Justice Abella. The years of sustained abuse committed in residential schools represent a profoundly shameful era in Canada's history. The legacy of the harms committed there consists of deep wounds, not only to those who were forced to attend, but also to our national psyche. The recovery process, when it is possible, is slow and painful. But at least there is a process, one that pays respectful tribute to the enduring character of the harm and the need to address it. The Indian Residential School Settlement Agreement is part of that healing process. When J.W. was a young boy at a residential school, a nun touched his genitals over his clothing. He was standing in line, waiting for a shower. He was wearing what he described as a little apron. In 2014, J.W. brought a claim for compensation in accordance with the Independent Assessment Process, IAP, the adjudicative component of the agreement, alleging that this incident fell within the following category of abuse. Any touching of a student, including touching with an object, by an adult employee or other adult lawfully on the premises which exceeds recognized parental contact and violates the sexual integrity of the student. J.W.'s claim proceeded in Manitoba. The hearing adjudicator concluded that the sexual intent of the nun was an element that had to be shown by the claimant. Despite the fact that she accepted that the incident had occurred as J.W. described, the hearing adjudicator denied his claim because he was unable to prove the nun's sexual intent. The issue in this appeal is whether J.W. was entitled to judicial recourse. Background. The agreement represents the negotiated settlement of thousands of individual and class action suits filed against a number of defendants, including the Government of Canada and various churches, relating to the operation of residential schools. The agreement includes a procedure for settling individual claims through an adjudicative process, provides for support services for former students, sets out a national procedure for healing, education, and reconciliation through the Truth and Reconciliation Commission, and creates a scheme for the general implementation of public programs to recognize and commemorate the significant and lasting harms caused by the residential schools system. While not admitting liability, the defendants acknowledged that harms and abuses were committed against Indigenous children at these schools. The individuals in the various classes of plaintiffs and potential claimants could opt out of the agreement and pursue their own litigation through the courts, but they could not take this route if they accepted compensation pursuant to the agreement. 2 avenues to compensation are available under the agreement: the common experience payment received by all eligible former students, and individual payments awarded to claimants who established specific compensable harms. These individual claims are adjudicated through the IAP. The rules governing these adjudications are set out in Schedule D to the agreement. The schedule describes which harms are compensable, what must be established by the claimant, and sets out a compensation scale. It includes both standard and complex track claims. Certain complex track claims may be referred to the courts by the Chief Adjudicator of the Indian Residential Schools Adjudication Secretariat, who is generally responsible for guiding, training, and assisting the adjudicators. This is the only category of claims which provides a mechanism for court access. There is a system of internal reviews. If the alleged error in an adjudicative decision is a palpable and overriding factual one, the scheme allows for one level of internal review. If the error alleged is a failure to apply the IAP model to the facts, there are 2 levels of internal review available. JW's claim is a standard track claim. That entitled him to an in-person hearing and the possibility of 2 levels of internal review. There is, however, no right of appeal to the courts. Because the agreement constitutes the settlement of ongoing actions, judicial approval was required. The parties brought the proposed settlement to the superior courts for approval, and between December 2006 and January 2007, 9 provincial and territorial superior courts approved the agreement through approval orders. Ontario was the first jurisdiction to approve the agreement, subject to certain conditions, in December 2006. In Baxter and Canada Attorney General, the decision accompanying the first approval order, Justice Winkler emphasized the enduring, harmful legacy of residential schools, which ultimately led to the agreement. Quote, "For 100 years, Canada pursued a policy of requiring the attendance of Aboriginal children at residential schools, which were largely operated by religious organizations under the supervision of the federal government. The children were required to reside at these institutions, in isolation from their families and communities, for varying periods of time. This policy was finally terminated in 1996 with the closing of the last of the residential schools, and has now been widely acknowledged as a seriously flawed failure. In its attempts to address the damage inflicted by, or as a result of, this long-standing policy, the settlement is intended to offer a measure of closure for the former residents of the schools and their families. The flaws and failures of the policy and its implementation are at the root of the allegations of harm suffered by the class members. Upon review by the Royal Commission on Aboriginal Peoples, it was found that the children were removed from their families and communities to serve the purpose of carrying out a concerted campaign to obliterate the habits and associations of Aboriginal languages, traditions, and beliefs in order to accomplish a radical re-socialization aimed at instilling the children instead with the values of Eurocentric civilization. The proposed settlement represents an effort to provide a measure of closure and, accordingly, has incorporated elements which provide both compensation to individuals and broader relief intended to address the harm suffered by the Aboriginal community at large." End quote. As Justice Winkler emphasized, given the goals of the agreement, significant and ongoing judicial supervision was necessary. As he said, supervising courts must, quote, "ensure that the administration and implementation of the settlement are done in a manner that delivers the promised benefit to the class members. Once the court is engaged, it cannot abdicate its responsibilities." End quote. Additionally, the court must be in a position to effectively evaluate the administration and the performance of the administrator, and, further, be empowered to effect any changes that it finds necessary to ensure that the benefits promised under the settlement are being delivered. Justice Winkler stressed that, as in all class actions, the courts must strive to protect the class members and ensure that the benefits they agreed to are actually delivered. In order to deliver efficient, coordinated judicial supervision of the multi-jurisdictional agreement, he suggested that each supervising court approve a court administration protocol. The approval orders in all other provinces were substantially similar, and stated that superior court judges were entitled to hear, quote, "requests for directions," end quote, with respect to the ongoing administration and implementation of the agreement. Paragraph 31 of the Manitoba approval order, for example, states, "This court declares that the representative plaintiffs, defendants, released church organizations, class council, the National Administration Committee, or the trustee, or such other person or entity as the court may allow, after fully exhausting the dispute resolution mechanisms contemplated in the agreement, may apply to the court for directions in respect of the implementation, administration, or amendment of the agreement, or the implementation of this judgment on notice to all affected parties, and in conformity with the terms of the agreement." The inclusion of the requests for direction provision in the approval orders contemplates that recourse to the courts is possible in circumstances where all internal mechanisms have been exhausted and directions are needed about the implementation of the agreement. The effect of the approval orders in the provinces was the certification of the actions as a class proceeding, subject to certain changes being made to the agreement. By March 2007, all 9 provincial and territorial jurisdictions implicated by the agreement took the next step and implemented the agreement by court orders. These implementation orders incorporated the agreement and addressed issues relating to its administration. Notably, the Manitoba Implementation Order concludes by stating that, quote, "The courts shall supervise the implementation of the agreement and this order, and, without limiting the generality of the foregoing, may issue such further and ancillary orders from time to time as are necessary to implement and enforce the provisions of this agreement," end quote. As proposed by Justice Winkler in Baxter, a court administration protocol was appended to each province's implementation order, stating that 2 administrative judges would be appointed to work in conjunction with the supervising judges from each province to oversee the administration and implementation of the agreement. The protocol stated that each request for directions brought by a party would be first made to one of the 2 administrative judges, who would then direct it to a supervising judge for a hearing if necessary. Supplemented by the applicable class proceeding regime in each affected province and territory, and the inherent jurisdiction of the superior courts, the approval and implementation orders gave the courts broad supervisory and administrative authority in overseeing the application and implementation of the agreement. This authority was integral to the agreement's goal of addressing the serious harms caused by residential schools and was a fundamental precondition to judicial endorsement. Ongoing judicial supervision was seen to be necessary to ensure that the benefits promised to the claimants, benefits for which they relinquished their litigation rights, were delivered in accordance with the terms of the agreement. This history demonstrates the foundational link between judicial supervision and the agreement. The existence of the agreement was contingent on judicial approval, and judicial approval in turn was contingent on ongoing judicial supervision. The Ontario Court of Appeal explained how this ongoing judicial supervision would be exercised in Fontaine and Duboff Edwards Height and Schechter. The decision concerned a legal fee dispute, which came to the courts by way of a request for directions. While concluding that judicial review in the administrative sense was unavailable, the Court of Appeal described the appropriate scope of judicial recourse. Appeal Justice Rouleau acknowledged that adjudicators cannot ignore the provisions of the implementation orders, and that they must apply the relevant factors in the agreement. But in his view, quote, "In the perhaps unlikely event that the final decision of the chief adjudicator reflects a failure to consider the terms of the agreement and implementation orders, then, in my view, the parties to the agreement intended that there should be some judicial recourse," end quote. He found that this judicial recourse was necessary to ensure that the bargain the parties agreed to was respected, a critical consideration given the vulnerability of the claimants. However, he held that judicial recourse was limited to very exceptional circumstances because the parties intended that the implementation of the agreement be expeditious and the agreement aimed to achieve finality. The Ontario Court of Appeal returned to the scope of the court's supervisory jurisdiction in Fontaine and Canada AG 2017 and concluded that the exceptional circumstances threshold applied to IAP adjudicative decisions. Writing for the court, Appeal Justice Sharp held that supervising judges should not conduct a detailed review of the factual findings made by the adjudicator, because that would allow judges to usurp the role of IAP review adjudicators. Disagreement with the result reached does not amount to a failure to apply or enforce the agreement. The British Columbia Court of Appeal also adopted the exceptional circumstances threshold in NN and Canada AG 2018. In that case, the majority concluded that exceptional circumstances exist if there is a gap in the agreement. The inability of adjudicators to reopen concluded claims in circumstances where there was new material evidence was one such gap, and therefore an exceptional circumstance warranting judicial intervention. The appellate authorities in Ontario and British Columbia have thus indicated that courts may intervene in relation to IAP adjudications when exceptional circumstances are present, a threshold which is met if there is either a failure to apply the terms of the agreement, including the approval and implementation orders, or if there is a gap in the agreement. I agree that there are compelling reasons for setting a high bar for judicial intervention in the IAP context. The parties went to significant lengths to make the agreement a complete code, with specialized training for adjudicators, levels of internal review, and creation of an IAP oversight committee responsible for monitoring the implementation of the IAP and the absence of any provision granting court access in the context of standard track IAP decisions. On the other hand, the necessity of ongoing judicial supervision was recognized when the agreement was approved, as noted by Justice Winkler in Baxter. Without ongoing judicial supervision, the agreement would not have been recognized. In overseeing the administration and implementation of the agreement, therefore, courts have a duty to ensure that the claimants receive the benefits they bargained for. The provisions of the approval and implementation orders contemplate ongoing recourse to the courts, with judges supervising the agreement to ensure that the implementation and administration of the agreement take place in the way the parties agreed. While the parties do not have a broad right to judicial intervention, they do have a right to the implementation of the terms of the settlement they bargained for. Judicial supervision plays a critical role in ensuring that the claimants receive the benefits that they were promised. The obligations in the agreement must be read in light of the agreement's spirit, to address the damage inflicted by or as a result of Canada's long-standing residential schools policy. Analysis. The question in this appeal is whether judges, exercising their supervisory role, should intervene in IAP adjudication. Schachter provides a useful starting point. Judges should intervene where there is a failure to apply or implement the terms of the agreement. Unauthorized modifications of the agreement are encompassed by this threshold. If an adjudicator changes the terms or requirements of the plain language of the agreement, this will amount to a failure to apply or implement the terms of the agreement. Courts have a duty to ensure that the agreement is implemented in accordance with the intentions of the parties as reflected in the agreement's terms. In determining whether an adjudicative decision rises to this threshold, supervising judges should be guided by the plain language of the agreement, viewed in light of its remedial, benefit-conferring objectives. Given the purposes of the agreement and the ongoing supervisory powers built into the settlement, I do not, with respect, agree with the Manitoba Court of Appeal's decision in this case that so long as the adjudicator refers to the relevant sections of the IAP, there is no basis upon which a supervising judge can intervene, regardless of how these sections are interpreted or applied. Reading apply and implement so narrowly prevents any meaningful judicial supervision of IAP decisions. In light of the purposes of the agreement, which include achieving a fair, comprehensive, and lasting resolution of the legacy of Indian residential schools, and a promotion of healing, education, truth and reconciliation, and commemoration, such an approach reduces judicial supervision to a search for ensuring that the right section of the IAP is applied, rather than ensuring that the rights promised by the section are being delivered. While finality and expediency are important goals, it is also crucial to recognize that claimants agreed to forfeit their litigation rights by not opting out of the agreement. Given this trade-off, it is paramount that the agreed-upon terms of the IAP model are applied and implemented in a way that is consistent with the parties' intentions. The court's supervisory power must permit intervention when it is necessary to ensure that the benefits promised are delivered. Judges, in short, have an ongoing duty to supervise the administration and implementation of the agreement, including the IAP. In exercising the supervisory role in the requests for directions context, judges can intervene if there has been a failure to apply and implement the terms of the agreement. In determining whether this failure exists, supervising judges will focus on the words of the agreement so that the benefits promised to the class members are delivered, In this case, JW's claim fell under the IAP category SL1.4, which is defined in the agreement as, quote, any touching of a student, including touching with an object, by an adult employee or other adult lawfully on the premises, which exceeds recognized parental contact and violates the sexual integrity of the student, end quote. JW's claim was rejected by the hearing adjudicator because, despite the fact that she believed JW's account of what transpired, she was not satisfied on a balance of probabilities that the perpetrator acted with a sexual purpose when committing the act in question. This was fatal to JW's case because IAP adjudicators, quote, must be satisfied in regard to any allegation of sexual abuse that what took place was done for a sexual purpose, end quote. In so holding, the hearing adjudicator relied on this court's decision in the Queen and Chase. Sexual purpose, she held, was a technical requirement of SL 1.4. JW applied for a review of the hearing adjudicator's decision. The review adjudicator concluded that the hearing adjudicator did not misapply SL 1.4 by requiring JW to establish the perpetrator's sexual purpose. JW's request for re-review was similarly unsuccessful. The re-review adjudicator held that the review adjudicator had not misapplied the IAP model. Having exhausted his internal remedies, JW brought a request for directions to the supervising judge, Justice Edmond. The supervising judge, Justice Edmond, described his role in the following terms. Quote, I have the power to review the decision of the re-review adjudicator to determine whether she failed to apply the terms of the agreement and specifically the IAP compensation rules. I accept that this is a limited form of curial review, reserved for exceptional cases, and that I must ensure that I do not engage in rewriting the agreement by effectively giving the requesters a right of appeal and/or review for which they did not bargain, end quote. Justice Edmond went on to describe the standard of review for a request for directions as, quote, ensuring that the re-review adjudicator did not endorse a legal interpretation that is so unreasonable that it amounts to a failure to properly apply the IAP to the facts of a particular case, end quote. Justice Edmond found 3 errors warranting judicial intervention. The hearing adjudicator replaced the words any touching in SL 1.4 with the words sexual touching. The hearing adjudicator imported a requirement of sexual intent on the part of the perpetrator, contrary to the plain language of Section SL 1.4, and the hearing adjudicator incorrectly interpreted this court's decision in Chase as requiring a sexual purpose as a necessary element of proving an act of sexual abuse. The hearing adjudicator described the question before her as, quote, whether or not the incident was sexual touching which exceeded recognized parental conduct, end quote. As Justice Edmond correctly noted, there is no requirement for the impugned touching to be sexual in SL 1.4. He also properly noted that the formulation relied upon by the hearing adjudicator leads to the illogical proposition that there could be sexual touching which does not exceed the parameters of recognized parental conduct. I agree with Justice Edmond that the hearing adjudicator's added requirement of sexual touching amounted to an unauthorized amendment to the IAP and the improper addition of a new threshold in the language of SL 1.4. This constituted a failure to apply and implement the agreement. In describing what JW needed to establish in order to demonstrate that the touching violated the sexual integrity of the student, the hearing adjudicator also stated that, quote, in this process, an adjudicator must be satisfied in regard to any allegations of sexual abuse that what took place was done for a sexual purpose, end quote. As Justice Edmond observed, nothing in the plain language of SL 1.4 indicates that the sexual intent of the perpetrator is relevant, and that clearly, and on a simple plain language analysis, a child's sexual integrity can be violated without a perpetrator having any sexual intent whatsoever. The effect of these 2 errors is the same. The hearing adjudicator's decision constituted an unauthorized modification of SL 1.4. By substituting the phrase any touching with sexual touching, and by adding a requirement of sexual intent unsupported by the language of the provision. The hearing adjudicator relied on additional requirements that were not agreed to by the parties. The unauthorized modifications of the IAP model amounted to a failure to apply or implement the terms of the agreement, warranting judicial supervisory intervention to ensure that the benefits promised in the agreement were delivered. These errors were compounded by the hearing adjudicator's misinterpretation of this court's decision in Chase, the third and final error identified by Justice Edmund. Chase dealt with the meaning of sexual assault in the criminal code. The court stated that, quote, sexual assault is an assault, which is committed in circumstances of a sexual nature, such that the sexual integrity of the victim is violated, end quote. The facts of Chase were as follows. The accused was a neighbor of the complainant, a 15-year-old girl. He entered the complainant's home, where she was playing pool with her 11-year-old brother, grabbed her around her shoulders and arms, and grabbed her breasts. Eventually, the complainant and her brother were able to call another neighbor for help. The accused was convicted of sexual assault in provincial court. His appeal to the Court of Appeal of New Brunswick was dismissed, but a conviction of common assault was substituted for the sexual assault conviction. In making this substitution, the Court of Appeal held that the word sexual in sexual assault should be understood as referring to specific parts of the body, genitalia in particular. Body parts with secondary sexual characteristics, like breasts, were not encompassed by this definition. Justice McIntyre, writing for this court, rejected the view that sexual assault was confined to contact with specific areas of human anatomy, and concluded that the test for sexual assault should be objective. Quote, applying these principles and the authorities cited, I would make the following observations. Sexual assault is an assault within any one of the definitions of the concept in Section 244 sub 1 of the Criminal Code, which is committed in circumstances of a sexual nature, such that the sexual integrity of the victim is violated. The test to be applied in determining whether the impugned conduct has the requisite sexual nature is an objective one. Viewed in light of all the circumstances, is the sexual assault or carnal context of the assault visible to a reasonable observer? The part of the body touched, the nature of the contact, the situation in which it occurred, the words and gestures accompanying the act, and all other circumstances surrounding the conduct, including threats, which may or may not be accompanied by force, will be relevant. The intent or purpose of the person committing the act, to the extent that this may appear from the evidence, may also be a factor in considering whether the conduct is sexual. If the motive of the accused is sexual gratification, to the extent that this may appear from the evidence, it may be a factor in determining whether the conduct is sexual. It must be emphasized, however, that the existence of such a motive is simply one of the many factors to be considered, the importance of which will vary depending on the circumstances, end quote. Applied to the facts of this case, Justice McIntyre concluded that there was ample evidence upon which the trial judge could have concluded that a sexual assault was committed. Quote, viewed objectively in light of all the circumstances, it is clear that the conduct of Mr. Chase in grabbing the complainant's breasts constituted an assault of a sexual nature, end quote. Chase, therefore, stands for the proposition that the sexual nature of the assault is determined objectively. The Crown is not required to prove the accused had any mens rea with respect to the sexual nature of his or her behavior. The hearing adjudicator in J.W.'s case, however, improperly interpreted Chase as requiring the complainant to prove sexual intent. She relied upon Chase to read in a mens rea requirement that does not exist in either Chase or the SL 1.4 category of the IAP. I agree with Justice Edmund that case law may be helpful, but it is the plain language of the agreement that must guide an adjudicator's reasoning process. Case law cannot be used to modify the language of the IAP as the hearing adjudicator did in this case. The hearing adjudicator's inaccurate interpretation of Chase thereby contributed to an unauthorized modification of the IAP model. As former Chief Adjudicator Ish rightly concluded in another IAP adjudication review decision, quote, there is no requirement in the IAP that the actor possessed a sexual intent before liability can be found for a sexual assault, end quote. The agreement was entered into to address the abuses caused by the residential school system, and the court's ongoing supervision of the settlement must allow judges to intervene where necessary so as to ensure that the benefits promised by the settlement are actually delivered. In my view, Justice Edmond properly identified a failure to apply the IAP model in the adjudication of JW's claim. These failures were confirmed on review and re-review. In intervening, Justice Edmond did not usurp the role assigned to the IAP adjudicators by reweighing factual findings. Instead, in the face of a failure to apply the terms of the agreement as agreed to by the parties, he intervened, remitting JW's claim for re-adjudication. As such, I respectfully disagree that recourse to a gap in the agreement is necessary in this case. Rather, judicial intervention was necessary in the face of an unauthorized modification of the agreement, contrary to the intentions of the parties. The nun's conduct in touching JW's genitals not only objectively violates the sexual integrity of the student, contrary to the definition of sexual abuse in category SL 1.4 of the agreement, it exceeds recognized parental contact. JW's claim is therefore compensable within the meaning of SL 1.4. This is the only tenable conclusion in light of the factual findings made by the hearing adjudicator. I note that the same conclusion was reached by a reconsideration adjudicator who reheard and allowed JW's claim before the Manitoba Court of Appeals decision was made. JW's is precisely the type of compensable claim contemplated by the parties to the agreement. Failure to correct the hearing adjudicator's interpretation in this case would unacceptably undermine the whole purpose of the agreement. I would allow the appeal with costs and reinstate the decision of the reconsideration adjudicator, allowing JW's claim plus interest.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.